At Sally.
Good morning. I'm Farron and I'm also a staff attorney at Sally.
Today we're going to be presenting confidentiality, ethics, and legal options for survivors of sexual assault, including a little introduction to Sally and what Sally does. So first, I have a little icebreaker question, which is, what is your favorite crime/legal show? I'm going to open the Zoom poll so that everyone can come in and give their answer. Oh, I actually don't have a Zoom poll. So if you could just put it in the chat, then we will see what everyone's favorite legal show is. We have Law and Order, Suits, Boston Legal, How to Get Away with Murder. And then if you have another show, you can just put that in. Looks like we have a lot of Law and Order. I know it's been on for a while. It's really popular. How to Get Away with Murder. I know it's really too. Okay, thanks everyone for participating. And the reason why we wanted to ask that question is because oftentimes, as you all know, TV shows that have to do with the legal system are often not as realistic as real life. And I'm sure everyone knows that, but we're going to explain a little bit more about the criminal system, the civil system, legal options, kind of to demonstrate how these processes function. By the end of this training, we hope you'll be able to satisfy these four objectives, and that includes identifying clients with urgent legal deadlines, describing major differences between the civil and criminal system. There are more than two, but hopefully you take away the two major distinctions. Compare and contrast confidentiality and privilege, and identify the difference between legal advice versus general advice. This one is really important because only licensed attorneys are permitted to give legal advice, whereas advocates and staff expected to provide more general advice and support, not legal advice. So we're hoping we can help you distinguish between the two. Here at Sally, which stands for the Sexual Assault Legal Institute, we provide legal services to survivors of sexual violence in Maryland, and we also train professionals that work with survivors of sexual violence as well. We have crime victims' rights representation that we do, which is assisting clients throughout the criminal process. We help with protection and privacy issues, including peace and protective orders, or as many people refer to them as restraining orders. We help with employment and education law matters, as well as family law matters, which includes divorce, custody, visitation, things along those lines. We also do a lot of safety planning, helping clients make plans according to their needs. Obviously, we get a wide array of clients and their safety plans vary widely as well, and we try to tailor those safety plans to their needs. We can also help with some housing issues, as well as financial compensation, either through the court system or through the state fund, which is called the CICB. And last but not least, we also help with some immigration issues relating to the U visa and T visa. On the right side, you'll see some things that we don't do at Sally. That civil tort cases, which we'll explain a little bit later, but it basically involves cases. We do not prosecute crimes. That is a state prosecutor's job. We'll get a little more into that. We do not report abuse or really anything without a victim's permission. We are not mandated. Everything that a victim tells us remains confidential. Unfortunately, we're not able to provide just emergency housing treatment, but we do provide referrals that do need assistance in those areas. And lastly, any case not based on sexual violence is something we're not able to help with. So if a case solely deals in domestic violence, like physical violence, we're not able to assist with any cases. And we'll go into a little bit more of what that means. Which of the following is Sally considered to be sexual violence? If you could select all that, that lost my. Can you see if there's a Zoom poll for this? I think I lost my little poll. If we don't have a poll, if you all want to put your answers in the chat, you can list all that apply. So this is a little bit of a trick question because actually all of these are considered sexual. Sally, obviously sexual assault, groping, and sexual harassment is a little bit obvious examples of sexual violence, but we do consider revenge porn to also be sexual violence, even though it's not necessarily physical. Stalking can be sexual violence, especially if it puts someone in reasonable fear of sexual violence. And then visual surveillance, if it includes, if it's of a sexual nature, so if someone is surveilling an individual, for instance, in a changing room, locker room, somewhere where they have a reasonable expectation of privacy and maybe disrobing or changing clothes. So these are all examples of what we could consider sexual. Next, we're going to talk about legal options. We're going to first go into civil options and then a little bit into criminal. So we're going to start with comparing the two systems. In the criminal system, the two parties are the state, in this case would be the state of Maryland, versus the defendant or the perpetrator. Whereas in a civil suit, it is a plaintiff, so usually the survivor of the violence versus the defendant accused. So that is a key difference that we want you to take away is that in a criminal suit, in a criminal case, the prosecutor is pressing charges against the accused. The victim is a witness, but not a named party to the case. They're a very important witness, and they do have certain rights throughout the criminal process, but they are not actually suing the defendant against the defendant like they would. The burden of proof is also very different in the criminal system versus the civil system. The criminal system has a very high burden of proof. It's referred to as beyond a reasonable doubt. Whereas in a civil suit, typically it's a preponderance of the evidence or that it's like not. Sometimes the burden is also clear and convincing evidence, which is, but it is much lower than the beyond a reasonable doubt. Another key difference to remember is that the punishment of losing a criminal case can result in imprisonment, fine, probation, or parole, whereas one would lose a civil case, and typically the loser would have to pay money damages or just money to the plaintiff, and an injunction can stop the accused or the defendant from doing something, such as stopping the abuse. We offer a wide variety of civil legal options. The one listed here that we don't offer, as we said, are tort cases, but we're happy to give referrals for those. When it comes to safety, there's two different types of what most people refer to as restraining orders in the state of Maryland.
Brandy, sorry to
Yes.
interrupt. Can you speak a little bit louder, and maybe turn off your video camera so it's a little easier to hear you?
Yes, but hopefully that sounds better. All right, I'll try to speak louder. So when
Thank
it
you.
comes to safety, of course, there are peace orders and protective orders, and those are what most people refer to as restraining orders. There are different eligibility requirements, different grounds for filing, available relief, and durations for each one. So when it comes to protective orders, to be eligible to file one, uh, a survivor must have either a qualifying relationship with the abuser or the perpetrator. That includes any of these listed qualifying relationships, or the survivor had to have been sexually assaulted by the perpetrator within the last 6 months. So if someone has any of these qualifying relationships, or they were sexually assaulted within the past 6 months, then they must file a protective order and not a peace order. We're only eligible for one or the other. Peace orders are for anyone that doesn't qualify those categories of qualifying relationships or were not sexually assaulted within the past 6 months. And then sometimes owner can file a peace order on behalf of an employee, let's say against a customer. So peace orders are a little bit more broad than protective orders. It's basically a catch-all. So anyone not covered by a protective order may be covered by peace order. There are also different grounds for filing. And again, the peace order grounds are a little bit more. So protective orders, they cover some of the more serious crimes, so serious bodily harm, just fear of imminent serious bodily harm. Someone need not actually, but if they were put in fear that they were about to be seriously harmed. Assault, of course, a rape or sexual offense automatically is grounds for protective. False imprisonment, most people refer to as not necessarily kidnapping, but holding someone in a place against their will, so not letting them leave the house or leave the property. Stalking, revenge porn, which we'll go into the details of a little bit more later, but it involves distributing graphic images. And then, of course, abuse of a child or abuse of a vulnerable adult. Some misunderstandings regarding the definition of vulnerable adult. It tends to have to do with elderly person, someone with mental health issues, or disabled people. So it's a little bit of a narrower term than most people think. These orders cover all of these grounds in addition to a few more. So that involves harassment, just using telephone facilities or electronic communication. This is a fancy way of just seeing or phone calls, messages. Certain kinds of trespassing, malicious destruction of property, or visual surveillance, like we covered earlier, where someone has a reasonable expectation of privacy, and that privacy is. So for peace orders, there are a couple of caveats when filing. The act must have occurred within the last 30 days, so it is a pretty quick turnaround. Not only that, but you must prove that the perpetrator is likely to commit the offense again. So this mostly refers to or applies to harassment, stalking, those phone calls we talked about, messages, because as you can imagine, it is difficult sometimes to will occur again unless there's already been their behavior. It's usually those patterns manifest as stalking. And when you file a protective peace, are a few things that you can ask them to do. That's to its relief. You're asking them to do something, to order the perpetrator to do something, to not do something. The most common relief available are these top three, which is stop the abusive acts, of course, not contact with the survivor, and stay away from the survivor. Also ask them to stay away from home, your school, your workplace. You can also ask them to vacate the home, award temporary custody or visitation if you have any children in common. Also order emergency family maintenance, which I sometimes think of as a temporary child support or temporary alimony. You can order or ask the judge to order counseling for alcohol counseling, domestic violence counseling, things along those lines. You can also ask for temporary possession of the home, car, and pets that you may have in common. And then surrendering firearms is a very common these protected. Of the most importance when someone is demonstrating any pattern of violence. I think it is really important to ask the judge to so that needs to. These orders are a little more narrow in this case. The top three are basically what peace orders cover. You can ask for counseling, but it is more rare than in protective orders. Protective orders also last longer than peace orders. They typically last for 1 year, but they can be extended for good cause. They can also be extended if the perpetrator violates the order, commits another act of abuse, or if they simply consent to extend. Whereas peace orders last 6 months and may be extended for 6 months. Protective orders are also useful because they can be made permanent if the perpetrator is convicted and sentenced to at least 5 years in prison for the act of abuse that you filed the protective. And obviously, a protective order means it lasts permanently, it lasts forever. It protects the survivor. So sometimes they get that just to it because it's a good idea to file a protective order just to ensure that you have the opportunity to develop protective if need be. You can't go back. You have to have filed the protective order first. You can't try to do it after time has expired. So to keep that process for filing these two orders are largely the same. So if the court is not open when a survivor would like to file the petition,
Sorry, Brandy, I accidentally removed your spotlight. I was trying to ask you if you could please try and leave the Zoom meeting and then come back in, and maybe that would help. We're still having a lot of difficulty hearing you.
oh,
Um,
okay, no problem.
sorry about that. And sorry, everyone. If you want to take a break or something, get some water, I apologize for the break. We'll begin again shortly. Just give us another minute or so.
Okay, I'm back. Can everyone hear me?
Yes. Let me spotlight you. Can you turn on your camera briefly just so I can spotlight you?
Of course.
Okay. And you should be able to share your screen now.
Okay. Mhm. Okay. Sorry about that, everyone. I hope you appreciated the break. So when it comes to process, the process for filing the protective order and the peace order are largely the same.
Hang on, Brandy, we can't see the screen yet. Sorry.
Oh, said I was sharing.
Oh, is it just me? Is anyone else able to see the screen slides? Okay, looks like no one else can. Okay, now we can see them.
Okay.
We just need in presenter view. Yep.
And I'm going to turn off my video just for the sake of action. Can everyone see my slides?
Yep, looks good.
Okay, great. Okay. So when it comes to the process of filing peace and protective orders, the process is largely the same. If the court is not open at the time a survivor would like to file the petition, then they can file an interim or they can obtain an interim order. And that's where you file with the commissioner rather than with the court. If a survivor would like to file for an order during court operating hours, they can file a petition and receive a temporary order. Either way, going either route, you must have a short hearing with a judge. It's typically pretty short, pretty informal, nothing to be super nervous about. You basically just explain to the judge why you are filing the order, and it's very common for the judge to grant the order. They will grant a temporary protective order that typically lasts between 1 or 2 weeks in order to serve the respondent, that would be the perpetrator, in order to give them notice of the protective order that was filed and notice of the final hearing. You must have a final hearing in order to be granted a protective order. A respondent can choose to attend or not attend. Either way, the judge will grant or deny the protective order. If the respondent does show up, whether or not they have counsel or an attorney with them, they may either consent to the order. There is an incentive to do this because if they do consent, it is a lot easier to shield the order from public record in the future. But they may also contest the order. And in that case, the hearing would be akin to a mini trial, wherein each side could ask the other side questions and argue either for or against the protective order. At the end of that mini trial, if that takes place, the judge will grant or deny the order, and either party has 30 days to appeal that order to a higher court. The second step is where survivors especially need legal assistance, because if that trial were to happen and the other side or the respondent does have an attorney, it can get a little bit hostile and heated, and it is best to have an attorney there with you for that second step of the process. It's not as necessary for the first step of the process. Does anyone have any questions about anything we've covered so far? I know the audio was cutting in and out, so if you need anything clarified, we can do that now. Hopefully the slides were straightforward enough.
Brandy, it looks like we have a question in the chat. It says, are there any protections in place if the court is unable to serve the perpetrator?
Yeah, so that happens a lot actually, and technically the protective order, the temporary protective order is in place. However, if the respondent or perpetrator hasn't received notice of it, then there's really no way for them to know not to contact the petitioner. However, if contact is made or if you were to see the perpetrator, out, You can immediately call the police and tell them you have a temporary protective order against the respondent and ask them to serve the papers on the respondent at that point. So it does offer some protection, but of course, if someone hasn't been notified that there's an order, they can't know until they know. But if you just keep that temporary protective order on you and notify the police, then usually they are able to step in right away. And then that order officially goes into effect because the respondent has notice.
Great. And it looks like we have another question here. Has the eligibility for protective orders changed?
No, and I can share, or we can probably share a link in when we post it to YouTube, but there is in the People's Law Library, there is more information on links to the statute of who is eligible for protective orders. Also, sometimes the judges like to think of these protective orders, they fall under the domestic violence umbrella. So sometimes if there's a little bit of a gray area, like someone, is a roommate or, former spouse or former romantic partner, those usually count as well. They basically want to cover any domestic relationships.
Great, thank you. And we have one more question here. It says, can a protection order be continued if the victim is in the hospital?
Can a protective order be continued? Oh, so delayed or postponed? Of course, that's always an option. You can always request that the court postpone the hearing, and especially if you can provide proof or justification, such as being in the hospital, I doubt a judge would deny a continuance for that. That's where it also helps to have an attorney in order to help you file those postponement motions, especially if you're in the hospital and unable to do it yourself.
Awesome. Those are all of the questions that we have for now. So if anyone else has any other questions, feel free to put those in the chat.
Okay, great. Moving on to our Zoom poll questions, which I do have up here. Oh, Alyssa, I think they, can you make me a co-host again? Oh, I think I see them. Okay. Let's see. Just one moment. All right, these are a little bit out of order. Let me launch this one and see if this is the correct one. Yes, okay. So we're going to go with this first question. So this is a hypothetical. A 22-year-old victim calls requesting legal services for a sexual assault she experienced 5 months ago by a stranger. She isn't sure what her legal goals are. For a protective order or peace order to remain an option, how urgently must she speak to a lawyer? So here we're just talking about the peace and protective orders, no other legal option. I would say the key points here are this was 5 months ago and it was a stranger. Give you a couple more seconds to answer. Okay, I'm going to end the poll. So most of you were able to answer this correctly. The answer is very urgently, and I think of that in terms of days or weeks. Now, the reason for this is that it says that the perpetrator is a stranger. So there is no qualifying relationship, which is usually what we look for a protective order. However, there was a sexual assault within the last 6 months, which means she would be eligible for a protective order, not a peace order. However, it has been 5 months, so there's only about 1 month left for her to file for a protective order or for that to remain an option. So this would be an example of a pretty urgent need for the clients to get in touch with an attorney in order to file within the next month. Oh, sorry, I forgot to share the results with you all. Okay. Moving on to the next. I have to stop sharing that poll. Okay. This next one involves a 35-year-old victim who calls and says he's been recently processing some childhood trauma and has realized he was sexually assaulted as a child by his babysitter decades ago. Same question. For a protective or peace order to remain an option, how urgently must he, sorry for the typo, speak to a lawyer? So the key things to note here are that this was decades ago. There is a relationship, but it's up to you to determine if that relationship would qualify under the eligibility criteria. And I'm going to end the poll. So again, most of you answered this one correctly. This would not be urgent just when we're talking about a peace or protective order, not any other options. And that is because the deadline for filing one of those orders has passed. It has been decades since this occurred. There was no qualifying relationship. A babysitter would not count as a domestic relationship. There was no sexual assault within the past 6 months, and the hypothetical doesn't include any recent harassment, stalking, anything like that. So while some of the other legal options may be urgent, this legal option would not be urgent. For this next one, a 70-year-old victim calls and says a strange man has been calling her and saying uncomfortable things to her over the phone. She's asked him to stop calling, tried blocking him, but he calls from a new number each time. This is a very common tactic. This has been happening frequently for over a year, and the most recent call was a week ago. Same question. How urgently must she speak to a lawyer in order to obtain a protective order or peace order? Okay, I'm going to end the poll. So this is correct. She should speak to a lawyer. Oh, I'm sorry. So it seems like the answer should be very urgently, and that's not necessarily wrong. Of course, sooner is better. However, we think that this is somewhat urgent, and that is because this has been happening for over a year. So although it just happened a week ago, so you could think she has a month to file, or within a month to file from that last call. Because this has been happening for over a year, it is likely to continue happening, which gives her a little bit more time. It's unlikely that this harassment is going to just stop within the next couple of weeks. So we mark this somewhat urgent, but if you put very urgent, that's not completely wrong. We're just looking more at the pattern of behavior. This wasn't just a one-time thing. It's been happening for a while, and it's likely to continue happening. So that one's a little bit tricky. Okay. We have just two more. A 22-year-old victim calls and said her recent ex raped her about 11 months ago. She just broke up with him after coming to terms with what happened. Same question. How urgently must she speak to a lawyer? So read this one carefully. Look at the relationship between them in addition to the timing of the sexual assault. They're both relevant here. Okay, ending the poll. So this is a tricky question, which is why there's a wide variety of poll answers. The answer is somewhat urgently. Now, I know you may be thinking it's not urgent because the assault happened more than 6 months ago, so the deadline is passed, or that it's very urgent because this happened 11 months ago, and maybe you saw something about the qualifying relationship, having a consensual relationship with the perpetrator within the last 12 months. However, this qualifying relationship is actually what allows her a little bit more time, despite the assault having occurred 11 months ago. And that's because it says she just broke up with him. So the qualifying relationship would be a consensual partner within the last year. So she does have quite some time before she is no longer eligible under that qualifying relationship of a consensual romantic relationship within the last year. That's why the answer is somewhat urgently. We have one more question. Last one, an 18-year-old victim calls and says a middle-aged woman used to follow him to and from the bus stop and sometimes would show up to the store where he works, but wouldn't buy anything. The last time she did this was 3 months ago, but he's still fearful, of course. Same question. How urgently must he speak to a lawyer for a protective or peace order to remain an option? So this is a pretty clear example of stalking. But it says the last time she did this was 3 months ago. But he's still fearful. And this is a pretty common scenario because 3 months isn't that long. So of course he would still be fearful, but the question is whether the court can order her to stay away from him under the eligibility requirements. Okay, I'm gonna end the poll. And like I said, this one is really tricky. So because no sexual assault occurred, there was no sexual contact or sexual act, and these two do not have a qualifying relationship, he would only be eligible for a peace order, not a protective order. However, because the last time she did this was 3 months ago, so it has not occurred within the last 30 days, the deadline has now passed, unfortunately, for him to file a peace order. Now, if she were to begin this behavior again, of course, he would have 30 days from that act to file the peace order, but at this point, he's not able to. Those are all the poll questions we have for now. I know there may be a lot of questions about them, and I don't want anyone to get too stuck in the nitty-gritty of those questions because they are difficult legal questions that even, attorneys have to think about or struggle with sometimes. But I just want to give you an idea of what the eligibility criteria and what the urgency is like for clients wishing to file a peace or protective order. And that's in order to, if you're juggling a lot of clients and you're able to, send a case presentation or send an email about a client to an attorney, maybe you can mark it as urgent if you're able to recognize that the urgency of filing a protective or peace order. So this isn't completely your job to determine the eligibility or the urgency, but it can facilitate communication with the attorney and kind of tip them off to how urgent a case may be. Okay. Next, we're going to talk about a little bit about housing. So what Sally does help with sometimes is helping to terminate a lease if the survivor is a renter. This usually happens if the perpetrator knows where the survivor lives and the survivor is nervous about continuing to stay in that apartment or house that they're renting. A protective order, a peace order, or a third-party report, which Sally would be a third party, or maybe your organization is a third party, can provide a report requesting that they terminate the lease without penalty. So as we know, usually you have a lease term, could be a year or 2 years, and when you break that lease term early, you are often penalized. However, if you are terminating that lease early because of a sexual assault, you can avoid that penalty. And these similar protections also apply to terminating, utility contracts when you're trying to move as well. In addition, it's not in the slide, but when a survivor wishes to move, there's also an address confidentiality program, which can allow them to hide their address from public record. And this has to be done, obviously prior to moving to a new address. They're not able to hide a current address from public record, but it is an option for moving to a new address. Just quickly reviewing the immigration options that we help survivors with at SALI. U visas are for victims of serious crimes. They must cooperate fully with law enforcement. However, the wait list for a U visa is extremely long. There's also a T visa for victims of human trafficking. The wait list is a lot shorter than for the U visa. And lastly, we sometimes help with VAWA self-petitions. This is specifically for spouses of legal permanent residents or U.S. citizens who are abused by their spouse. And this is to prevent a citizen or legal permanent resident from being able to continue to abuse their spouse under the threat of turning them into immigration if the survivor spouse is not a citizen or doesn't have legal status. SALI also sometimes helps with employment law matters if someone experienced sexual harassment or sexual assault at work. Usually a survivor must go through the administrative process first with the EEOC, which is a federal agency, the Equal Employment Opportunity Commission. But Maryland also has its own, which is called the Maryland Commission on Civil Rights. Typically, to apply federally, to submit a complaint federally, an employer must have 15 or more full-time employees, but that's no longer the case because Maryland allows for just one employee to be sufficient. The EEOC typically takes on the rights that the state gives to complainants. Typically, these complaints are against the employer, not necessarily the perpetrator. Typically has to do with how well the employer handled the complaint of sexual assault or sexual harassment. When you file a complaint with the Maryland Commission on Civil Rights, it's also dual filed with the EEOC. Sometimes the EEOC will pass the complaint along to the MCCR just because the state of Maryland is more likely to be in closer proximity and have adequate resources to handle a complaint more quickly than a federal agency would. You can also file with a county. Not every county in Maryland is able to be, you're able to file, but some counties do have their own office. And the idea is that the more local the agency is, the easier it is for them to investigate and interview witnesses, things like that. There's a 2-year deadline to file a complaint unless it involves ongoing harassment. Then you just must file within 2 years of the last incident of harassment, although the agency will still investigate all prior acts of harassment. And then typically survivors must go through this process before they're given by the EEOC or the MCCR a right to sue in court. There's a similar administrative process that should be followed when a sexual harassment or sexual assault takes place at a school. That includes universities, of course, but also high schools, elementary schools, schools of all levels. There's this similar formal complaint process similar to the EEOC. And this can result in the perpetrator, if they're a student, being suspended or expelled. If they're a teacher, obviously they could be fired or suspended. The school can also make housing accommodations, for instance, moving the survivor to another dorm or another housing building away from the perpetrator. They can order stay away orders mutually, which is similar to those peace or protective orders where there's no contact. Now, it is important to note that this new presidential administration has placed the 2020 Title IX regulations back into effect, as opposed to the 2024 regulations that were in place. And these 2020 regulations are a bit narrower and a bit less favorable to survivors. When it comes to family law, we're talking about divorce, custody, visitation, and child support. You don't need to memorize this or anything. We just talk about how Maryland does make it relatively easy for spouses to end a marriage. And you're also able to terminate parental rights in some cases as well. We did talk about getting temporary custody or visitation or emergency family maintenance from a peace or protective order, but those are temporary. In order to make those permanent, you would have to file a family law case or file for custody or visitation. So those are all the civil options that Sally provides services for. There's also the criminal aspect. Now, when it comes to the criminal legal process, Sally mostly does crime victims' rights representation. We'll get into that a little bit. But basically, the overview for the process is that a survivor reports the crime to law enforcement. They can also file charges with the commissioner's office, but typically a police report is the common way to report. The law enforcement office should do a full investigation, collect evidence of the crime, and hand that evidence over to a prosecutor, which is a state attorney. The prosecutor has the sole discretion to press charges against the perpetrator. Contrary to popular belief, it's not actually the survivor that presses charges. It is the prosecutor. And if they decide not to press charges, there's really not much anyone can do. They do have a lot of discretion. If the prosecutor does decide to press charges, then there's two possibilities. Either they negotiate a plea agreement with the perpetrator, which is basically a compromise, or there's a criminal trial. And that is mostly what we will see on the TV shows we talked about earlier. You don't see a lot of plea agreements on those shows. Although the vast majority of these cases result in a plea agreement. That is much more common than a criminal trial. We've listed some of the most common crimes that we get reported or are reported when it comes to sexual violence. Now, something to note that when it comes to second-degree rape, as of last year, it no longer requires force or threat of force in order to be considered second-degree rape, which is a huge win for survivors. Because as we know, a lot of times these acts are coerced or a survivor freezes up and there's not necessarily a threat of force. The state of Maryland still would consider that second-degree rape despite no force. I also have the elements for stalking here, which we talked about earlier. It does require intent to place someone in fear, especially in fear of bodily harm, or intent that it would cause someone serious emotional distress. So there is an intent element there. Same when it comes to harassment and revenge porn, there must be an intent to harass or annoy another person. The person being harassed should ask them to stop or warn them to stop, and then they continue to do it. That would constitute harassment. With revenge porn, there's a similar intent requirement where not only must the perpetrator distribute the images or recordings, but they must also intend to cause serious emotional distress. And we have some of the statutes of limitations for those crimes here. There are some other crimes listed, but it's just important to note that for felonies, which include rape in the first or second degree or third degree sexual offenses, there's no limit for reporting those crimes in the state of Maryland. Whereas when it comes to misdemeanors generally, so that would be the fourth degree sexual offense, which usually is sexual contact like groping. Typically, survivors have 1 year to report that to police. There is no limit or deadline for reporting revenge porn, which is also a huge recent win for survivors. Lastly, we're going to talk about crimes against children because they are a little bit different than crimes against adults. So when it comes to sexual acts against minors, those who are under 18, they're always prohibited if there is one of those relationships similar to what we talked about before to the child. So if the perpetrator is, a member of the household, a caregiver, a parent, anything like that, the state of Maryland considers a minor not able to consent to sexual contact or sexual acts based on that relationship. And that is although in Maryland, the age of consent for sexual contact is 14. And the age of consent for, more sexual acts is 16. Now it gets a little complicated with the age gaps here. But basically, the bigger the age gap, the bigger the penalty is what I would take away. There's a higher penalty if there's a 4-year age gap. There's a higher penalty if the perpetrator or the adult is over 21. Oh, and then also there are different rules for a person in authority having a sexual relationship with a minor, depending on the age. If the person in authority works at a school that the minor is at, then it's absolutely prohibited, any sexual contact. However, if the adult is participating in a program geared towards minors, then there's a 6-year age gap required for it to be a crime, for there to be any sexual contact or sexual acts. So Maryland does protect the minor more depending on the qualifying relationship as well as according to age gap. Now, when we talk about a person in authority with respect to a child, if you want to put in the chat some examples of someone you think would be considered a person in authority over a child. Teacher, definitely. Yes, a pastor, faith leader, coach is a really good one. Babysitter can be considered a temporary caregiver, so yes. A police officer is more of a person in authority generally, not necessarily over children specifically. So we are speaking of a person over authority of children directly. So yes, a camp counselor. Bus driver, yes, anyone providing daycare or after school care. Parents, yes, those parents and anyone in the household are already covered under that last slide, but yes, of course, they are a person with authority. Some that I don't think I saw that you may want to note are tutor. Yeah, so some people are people in authority, like a friend's parents or a social worker, but we are trying to think of people that are working or volunteering in a program specifically designed for kids. So that could be Boy Scouts, camping, any government program that's specifically geared towards kids could also qualify. Okay, moving on, great answers. So I did talk a little bit about crime victims' rights representation. That is something that Sally provides to clients and survivors of sexual violence. In the state of Maryland, crime victims have the right to be informed of any court proceedings that relate to the crime that they suffered. They also have the right to be present at those proceedings, heard at those proceedings. When they have the right to be heard, that is typically in the form of a victim impact statement during a sentencing hearing, or also to be heard by the prosecutor during plea negotiations. They also have the right to seek restitution, which is kind of a financial compensation for the crime, as well as representation, because again, the prosecutor does not represent the victim. The prosecutor represents the state of Maryland. So we are able, as attorneys, to provide representation, which just entails that these other rights are being protected throughout the process. Like I said, restitution is a payment. It is court ordered, and it's a payment that the defendant makes to the survivor to compensate for costs stemming from the crime. All crime victims have the right to ask for restitution. Judges don't have to order it. It's up to the discretion of the judge. And the victim must have provable expenses in the form of receipts or any other kind of documentation. And because the expenses must be provable, it does not unfortunately cover emotional distress. A way for a victim to be compensated for emotional distress would be through that civil tort case that we discussed earlier. Typically, when a crime occurs, a sexually violent crime, law enforcement must offer transportation for the victim to the hospital, typically to get that safe exam, that forensic exam. The victim must receive free medical help, again, often in the form of that safe exam and any treatment that may be deemed necessary as a result of that exam. The victim often receives HIV testing, but they can also test the offender for HIV as well. We've discussed this a little bit, but when it comes to CVR, crime victims' rights representation, as crime victims' rights attorneys, we will just make sure that those rights are protected, facilitate communication with the prosecutor. Also, it's important to note that the victim does not have attorney-client privilege with the prosecutor because the prosecutor does not represent them. We'll get a little bit more into privilege in the next module. This way, the victim is able to ask the crime victims' rights attorney, things that they would like to remain confidential that they wouldn't be able to ask the prosecutor because of that lack of confidentiality. Crime victims' rights attorneys can also protect victims from getting their privacy invaded. Sometimes a defense attorney wants to subpoena a victim's medical records, therapy records, educational records, immigration status. And as attorneys, we can help fight against that in court by filing motions against it, explaining why it's an invasion of the victim's privacy. I mentioned this earlier, but the CICB, or the Criminal Injuries Compensation Board, is another way for victims to receive compensation for expenses related to a crime. This is in addition to the restitution option and the civil tort option. A lot of survivors prefer this option because it doesn't involve going to court. It just involves applying and submitting receipts to the state agency. And this is something that Sally is able to help with, but also isn't too difficult for a survivor to do on their own. Now, the rules are changing in July. So these rules here, or eligibility requirements, are only in effect for the next month. So for the past several years, the victim had to have reported the crime within 2 days, except for good cause, which sexual violence often is sufficient to establish good cause. And the CICB would provide reimbursement for medical bills, therapy bills, lost wages, but it didn't include relocation costs, and applicants only had 3 years to file after the crime took place. Again, there was a good cause exception. However, starting July 1st, The reporting requirement to law enforcement is completely eliminated, which is a huge one for survivors because, as we know, there are a variety of reasons why a survivor would choose not to report these crimes to law enforcement. It still only covers provable expenses, so receipts or documentation are absolutely necessary. But it does now provide, starting July, reimbursement for one-time relocation expenses, and then transportation and childcare expenses to and from medical appointments, which is huge. These expenses could often be a barrier for survivors to seeking medical or therapy treatment. So this will definitely help survivors with the financial burden of that. The CICB is also expanding the maximum awards that they'll give out for certain things like funeral expenses, crime scene cleanup, and counseling. And then they also increased the deadline to 4 years after the crime, giving survivors some more time. Lastly, even though this isn't something that Sally helps with, it can be helpful to know the most common torts related to sexual violence and the statute of limitations for them. Again, these aren't criminal statute of limitations, these are civil statute of limitations. So the deadline to file a civil lawsuit. For assault, the deadline is 1 year, and assault typically involves the fear of imminent harm. So not necessarily actual harm or actual physical contact, but putting someone in fear of harm. And then battery would be actual physical contact and harm. Revenge porn and negligence, survivors have 3 years to file suit for those torts. However, for child sexual abuse, there's absolutely no statute of limitations anymore. This got cleared up, I believe, last year, which is great news for, child victims or people that have just now realized after decades, like in our hypothetical, that they were abused and they didn't realize it before. So now there's no deadline for them. Anyone has any questions before I pass it over to Farron? You can put it in the chat. I know that was a lot of information. And again, we don't expect advocates or other staff to know all of this information. Sometimes just familiarizing yourself with it can help facilitate communication with the attorney and with clients. I don't see any questions for now. Maybe think about it and we can always address them later. So for now, I will pass it over to Farron, where she's going to cover confidentiality and privilege, and then legal versus general advice.
Hello. So like Granny said, I'm going to start with confidentiality versus privileged information and kind of explain the differences to everyone. So if you go to the next slide, Brandy. Thank you. So as you can see, the two are quite similar. They both protect survivors from disclosure of communications from between professionals and either the client/patient, whereas confidentiality is to any third party in any context, whereas privilege also protects against disclosure to any third party in any context, but it also adds protections in the court context. So something we do at Sally to ensure protection is when I call a client, I ask if anyone else is in the room to ensure that no one else is in the room and that the client themselves is in a safe and private place. So we don't have another third party present, so we don't break that privilege. So privilege is the stronger protection of the two. All privileged information is confidential, but not all confidential information is privileged, kind of like the square rectangle. So as you can see, privilege is a little bit smaller and it's a stronger protection. So some examples of information that you all might run into. So to understand like where the type of information you're running into falls between the two. So privilege typically protects mental health providers, attorneys, clergy, spouses. You're not required to testify against yourself, so self-incrimination, that privilege, whereas confidentiality is medical providers, also mental health providers, attorneys, advocates, and then some grant recipients. Sally and many of your organizations may receive grants, and those grants could have confidentiality provisions within them. So make sure you're kind of aware of those. Talk to your organization about them. I'll explain that a little bit more on the next slide. So kind of where the laws for these come from. So for privilege, it's state and federal law that create these protections, whereas confidentiality is also state and federal law, but it's also professional ethics rules, professional licensing, your organization's internal policies, and like I just mentioned, grant requirements. So if you receive grants under the Violence Against Women Act or Victims of Crime Act, those acts have confidentiality provisions within them. So those add extra protections when you receive grant funding under those. So like at Sally, we have those. So we have, our typical attorney-client privilege, and then we have those VAWA grant requirements as well. So just make sure you're aware of what funding your organization receives and how that may affect how your organization needs to handle information. So now we're going to do a quick Zoom poll. Can everyone see that? Are communications between attorney and client privileged or confidential? So this is a little bit confusing because attorney can kind of, like I said, fall on both sides. Typically, we view communications between a client and an attorney as privileged. We give it that higher protection, even though it's attorney-client confidentiality, but it's attorney-client privilege. So they're privileged, they get that higher protection, just so you know that. So attorneys and clients get that higher privilege protection. Okay, and then we'll do one more. Mental health records, confidential or privileged. Looks like a lot of people have answered. So mental health records can fall kind of on both. Typically, they get that privileged protection. They get that stronger protection. So just so you're aware, mental health records typically get that privileged protection. There are some cases where they're confidential, but they typically are getting that privileged, stronger protection. Just so you can just be aware of that, they are typically getting that stronger privilege protection. All right. Brandy, if you could go to the next slide. So a little more information about confidentiality versus privilege. They both typically belong to the patient and the client, not the advocate or the attorney. So the patient or client is the person who gets to waive the confidentiality or the privilege. There are some exceptions to this. So in mandatory reporting or child abuse or abuse of a vulnerable adult, typically sometimes when people are under 18, and there are other exceptions that vary by profession, if the patient is a threat to themselves or others or against malpractice claims. So if you need more information about the mandatory reporting, I would recommend that you take our self-paced training module on child sexual abuse. There'll be more in-depth information on child sexual abuse and mandatory reporting laws. And as an attorney in Maryland, I am not a mandatory reporter, but you may be based on your role in your organization. So it's make sure you're aware of that if you're a mandatory reporter. So you are following those obligations, and that is an exception to confidentiality and privilege. So you want to make sure you're aware of that. So you're properly reporting, as that's a law and you want to make sure you're following it. Thank you. So typically the waiver confidentiality or privilege is all or nothing. So you want to make sure that when the person is choosing to waive confidentiality or privilege, they understand that they're waiving all of it. There are rare exceptions where you may be able to carve out some of the privilege, but that is very rare. So typically you're waiving the client is waiving all of it. So that you want to make sure that they understand that. So in this example, Maria wants the Rape Crisis Center advocate to give expert testimony that Maria's husband physically and sexually abused their 6-year-old daughter, but not that Maria waited a month to go to the police after she found out. So if Maria waives the confidentiality in that scenario, all of that information is coming in. The fact that she waited is going to come in as well. She cannot kind of carve out the fact that she waited. So you want to make sure the client understands that part of it, because typically people are like, well, I don't want you to tell them that part. And that's not really how this works. If you go to thank you, Brandy. So why do we have privilege? We want to encourage free and effective communication. We want people to be able to talk to certain people. So we want to protect those relationships. You want to be able to talk to your attorney freely, and that your attorney's not going to turn around and tell everyone or tell the judge or tell opposing counsel. We want those communications to be protected. Or also, like your clergy, you want to be able to talk to your clergy and have those communications be protected. We view those relationships as kind of sacred. So the law protects those relationships. We also want to protect children, and we want to have people have their constitutional rights to a fair trial, to confront witnesses. So the legislature could protect these relationships so everyone can have their rights protected as well. So we're going to go through kind of an example if the privilege is broken in this situation. You can just think about it, or you can put it in the chat. Either way is totally fine. So an advocate does an intake with the client, and then the advocate tells the attorney about the intake so the attorney can prepare for a legal call with the client. Do you believe that privilege is broken in that situation? Great. I see some people answering in the chat. Yeah, no is definitely correct. So at Savly, our advocates can communicate with us about what they do our intake, so what's going on, so we can communicate with them, and they can communicate with us about the client. So they're kind of protected under this attorney-client thing because they're working with attorneys, and that they're not a third party that's going to break attorney-client privilege because of their role within our system. So that's great that everyone is getting that. Good. So the next situation is an attorney and their client are having a conversation. The client does not speak English, so a bilingual advocate is present to help the parties communicate. And then the client's friend is also present during the call. So would privilege be broken in that situation? You can put it in the chat or just think about it, but I'll give everyone a minute. Okay, great. So I just want to make sure it's clear. The privilege is broken because of the friend's presence, not because of the bilingual advocate. An interpreter is allowed to be present and not break attorney-client privilege. It's kind of one of the exceptions to the rule. Like an advocate could also be present. At Sally, we use bilingual advocates often to interpret our calls. So that advocate being present is not breaking my attorney-client privilege when I'm speaking to a Spanish-speaking client if I needed a Spanish-speaking advocate. But that friend's presence is a third party that would break the privilege. So like I said earlier, at Sally, I just make sure my clients are alone and no one else can hear our conversation. So I'm protecting that privilege with my clients. So just be aware of that if you're talking to clients, just make sure you're asking that. Your organization may have another way to go about it, but just it's a good thing to keep in mind. Does anyone have any questions before we move to the next topic? Give everyone a second. Okay, I think we are good to move. So we will be doing advocate testimony and a little bit of information about advocate records. I think we have time for the clip. So we can maybe play this is just kind of an example of expert testimony, but a little bit funny, not a question. Yeah, definitely.
All right, Fran, I'm not sure how to play the clip.
If it's not playing in the slides, you can always send me the link and I'll send it out in the follow-up email.
Okay, great.
Oh, do you ask the friend to step out or do we ask the client to tell the friend? So that's a great question. I typically kind of explain to them that the privilege is going to be broken and what they're saying to me is no longer protected. So I ask for them to have the person step out or take me off speaker, or I'm happy to call them back at another time. It's kind of based on the situation. It also with minor clients, may want mom or dad present, but I really prefer to speak to the client alone because mom or dad is breaking that privilege as well. So it kind of depends on the situation. If mom or dad can hear me or the friend can hear me, I'm happy to ask them to step out. But I try to explain why I need them to step out because I want to protect that confidentiality. Because a lot of times people don't understand if they think like, oh, well, I want this person to be present, so it's okay. But either way kind of works, just kind of how you feel most comfortable. If I'm not the protective order, so for protective orders, it's typically 6 months they can keep trying to serve. And then after that 6 months, it will expire. We can go beyond that clip. So advocate testimony. So as an advocate, you can be an expert and a fact witness. Um, Expert witnesses help educate the judge or the jury about domestic and sexual violence. Generally can offer their expert opinions about a specific case because you have specific knowledge about domestic and sexual violence and sometimes about how trauma works. So you'll be educating the judge and the jury about that, but you can also be a fact witness. So fact witnesses are like if you're at the scene of a crime and you see the crime actually happen, like you see the car accident occur, and you are called to testify, you're telling the judge and the jury, oh, I saw these cars collide. That is, you're telling them what you saw firsthand. So you, as an advocate, you can be both. Just kind of depends on the situation, just so you know that. So as an advocate, you will likely keep records of some kind, and people may want access to those records. So why would you release those confidential client records? So if the client wants them, they can have access to their own records. If the survivor's attorney wants access to the records, they can have them, of course, with the survivor's consent. Then that release needs to be in writing. The state's attorney may request them or subpoena them. So you also want to have that release from the survivor if the state's attorney requests them. The state perpetrator's attorney may subpoena records. I've had that happen. And a court order. Just so you know, even if they're subpoenaed or there's a court, you can try and fight them. So don't necessarily just hand over your records. But we just want you to be aware that your records could end up in court one day. So we just want you to keep that in mind when you're making those records. So when you're responding to requests for records, talk to your client. What do they want? It's their decision. You want to make sure you're empowering your client. It's their decision some of the time, not all of the time, but you want that consent to be informed. So tell them the pros and cons. Make sure they understand that they're waiving all of their privilege if they give these records over. You want that release to be voluntary. It cannot be a requirement for receiving services if they give you access to their records, and that release needs to be in writing. Also, based on grants, there may be additional conditions like the Violence Against Women Act. The release needs to be time limited. So just make sure you understand that when you're releasing records, you want to make sure you're following all the requirements. And so talk to an attorney at your organization as well. So has anyone heard of a subpoena before? I know a lot of people like those legal shows, so you might have heard that in those legal shows, and it can be a little confusing to what it actually is in practice. So it's a legal tool that requires someone to come to court to testify or produce something like documents or records. If you receive a subpoena for yourself or your records, you should notify your supervisor, director, legal counsel immediately. And now, immediately means now. Subpoena response times are very, very quick turnaround. So you want your attorney to be able to fight it properly, respond adequately and in the right amount of time, because otherwise the attorney could get in trouble. Don't necessarily just turn over all your records, even if you receive a subpoena. Talk to your attorney at your organization or your supervisor. Talk to your client. What do they want to do? In some cases, the court may still order for you to turn over the records, even if the client doesn't want you to. But it can be an argument against turning over the records that they don't want. The client doesn't want their records turned over, that they're confidential, they're privileged. There are legal protections for confidential and privileged documents. That's more for the attorneys to worry about. There are like alternative remedies, but just make sure understanding that subpoenas are very serious and that they're urgent to talk to an attorney at your organization and your supervisor if you ever receive them. So because your records could be subpoenaed or you may need to testify in court, just be aware of that. You want to give context to bad facts, so they're in the record of your records. You do not want to have to, it's easier than having to explain on the witness stand because your records may just be subpoenaed, not necessarily you as well. So instead of the client appears to be an alcoholic, explain that as typical for many sexual assault survivors, the client self-medicates with alcohol. It doesn't demonize the person for their behavior as much and explains like the trauma response going on with it. So we have a few more examples of unfavorable notes and then how you could make those more favorable to your client by providing context. So in these examples, the victim is a drug addict. The client did not say no. She did not fight back. The client hit the perpetrator. So you can think about how you would change these and provide context. I'll just give everyone a second to think about it. If you want to put some ideas in the chat, you are welcome to, but I will tell you how I changed them to provide some context. Obviously, the context is going to depend on your client and what's going on in their case. And your organization may have specific ways they want you to talk about certain topics, because certain topics are extra sensitive. And especially right now, there are additional topics that may be extra sensitive. So there may be ways that your organization particularly wants you to handle those. So just be aware of that. Your organization may have particular policies on certain topics and how to write about them and log them properly. So kind of what I did is I explained the situation a little bit more. So explains that why the victim was using drugs and alcohol, as there's a lot of the stigma around drug and alcohol addiction in society. So explains the abuse and how she is using it to cope with her pain, and now she's receiving counseling. Yes, person first language, exactly. Drug addict is very stigmatizing. Exactly. So it helps kind of explain the situation and using more person first language, which is a great thing to point out. As well as the second example explains the trauma response. There's obviously a lot of ways people think victims should act in society, and that's just not based in the reality of being a survivor or a victim of a crime. So it kind of explains the trauma response, which a lot of people still don't know about and understand. So it's really great with you all's expertise to explain that and have that in your notes, giving context to the way that the person acted. Does anyone have any questions? Shatterproof has a great resource for language. Oh, thank you for sharing that. That's great to know. Okay, and then we will do the unauthorized practice of law. So as advocates, there are things you can do and can't do as non-attorney advocates. So you can provide the victims with basic information about the existence of legal rights and remedies, and basic information about the manner in which judicial proceedings are conducted. You can also assist a victim in filling out a legal document or pleading by explaining unfamiliar terms, or explaining where on the form a victim is to provide certain information and helping them fill out the form, but only recording exactly the victim's words. You don't want to be putting your own words in there. That crosses the line into unauthorized practice of law. So just be careful if you're helping a client or a victim fill out a form. Some courts allow you to sit at trial table with the victim. So just be aware, some courts do and some courts don't, of the court rules, and could be also be state rules. It kind of depends. What you can't do is provide advice relating to a victim's rights or remedies, including suggesting the pursuit of a particular remedy, provide information about legal aspects of judicial proceedings, how to present a case, call witnesses, introduce evidence, using your own language, filling out those forms, like I mentioned before, and you cannot advocate in front of a government representative on behalf of the individual victim. I think we have time for maybe like one poll. So I'll just end with our last one. So what objective do you feel most confident about in implementing your interactions with clients?
Sorry, Farron, that was actually for the end, but we can skip to it since we don't have
Yeah,
much time.
we're about end of time, so just skipping to the last one. No. Okay. So it looks like okay, great. We have a kind of a range of what people are more comfortable with, but hopefully and feel most confident about implementing, but hopefully everything makes a little bit more sense. And obviously it's a lot of information at once, but hopefully it will make for sense as you use it in practice as well. But if you have any questions, you can always, Alyssa has our contacts as well. We're happy to answer questions beyond this because things may pop up as well. But thank you, everyone.
Yeah, thank you both for this presentation. So I put the anonymous evaluation link into the chat. Again, we greatly appreciate all feedback as we are constantly striving to improve. If you are seeking a certificate of attendance or a certificate for social work CEU credits, you must complete the evaluation form. Upon submitting the evaluation form, you'll gain access to the certificate request form. If you are in the military and are having trouble accessing this evaluation link, feel free to email me and we'll do a workaround so you can access the evaluation. I'll be sending out a follow-up email later today with a copy of the video recording, the link from the video for the one slide, the PowerPoint slides used today, and I'll send out Farron and Brandy's contact information if you have any additional questions for them. So thank you all so much for coming, and we hope to see you tomorrow.